the courts don't want typically to grant repossession orders. It's actually quite difficult. There's huge protection around family homes. Okay, so invariably, they'll keep adjourning if the bank haven't got the documents in order, or if the bank is selling the debt to another entity, they'll adjourn it again, and they keep adjourning. So, somebody might have gone through maybe three, four, even five adjournments, and that could be over a number of years. But ultimately, if there's no defence, or if somebody doesn't turn up, for example, the judge may grant the order for repossession, and they'll normally grant it with a stay. And all that is, a stay means is that they're giving the person time. That stay might be 6 months, that stay might be 9 months, and that's typically to either move, or move house, or they have somewhere else to go or whatever. But it's equally giving them time also, if they haven't already, seek the advices of an insolvency practitioner. Okay, and what I can do is I'll go to the insolvency court and I'll get what's called a protective certificate. Okay, and that stops the proceedings.
Okay.
Okay, and it also stops the order for repossession. Okay, and then I can ultimately go and make a proposal. So if I've met the client, I've done the maths, and I've said, well, actually, you can afford to pay this. Let's give it a crack, and let's see, can we do a deal with the bank? Then the repossession proceedings will stop temporarily, and I can make that proposal to the bank to see, will they do a deal? And if they do a deal, well, then ultimately the repossession order is stayed while that deal is in place, ultimately. The only time that wouldn't succeed is if they ended up not seeking anyone's advice, right? Or not going anywhere. And then the stay finishes. In other words, the date finishes. And then the sheriff lands and executes the order. And then, fortunately, it's game over.